David, your wellnesspreneur and wellnesspreneur consultant at Spirit Law, and in this video, the final one of this series around contracts and legalese and terminology, I am just covering off what documents appear and what triggers those documents as to when you're going to need them in your business. Because there's lots of documents, it seems, and it can be a bit overwhelming and a bit confusing. And I often see a lot of posts of people saying like, I need what, when do I need it? I don't understand. So I thought this video might just give you guys a slightly clearer idea about what you need and when. So the first thing is going to be your waiver document. So this is when you're going to be getting a new client or you're updating something that you need the client to sign. A waiver is a document when your client is giving up a right to something and you need them to do this in writing. Because if we go back to the first video that I talked about with the contracts and when it happens, when it's formed, the key thing with giving up a legal right is it needs to be in writing and you need that to be signed by the client. So often we put the waivers with health forms when we're taking a new client in, and in that waiver you're going to be asking them to waive their right to sue you for potential damage and loss as a result of the relationship with you. So that's when you want to have a waiver, is when you've got a new client that you're going to be working with and you want them to waive those rights, or you've updated your T's and your waivers and you need them to update signing those waivers. Now in the UK and Australia, it's arguable that a waiver can be used whether it's a paying client or a non-paying client. So that includes whether it's a donation or a free class that you're providing. However, in the US, the general approach is definitely that does not count if there's no money being paid. So a waiver should not be used in the US when there's no money. You want to have a disclaimer. Now, what I would say is it's still worth doing a waiver regardless of whether or not there's a payment. And it's still always a really good idea to stick it in front of the clients because it reminds them of their own responsibility to take care of themselves and call themselves to account in their own wellness practice, and to also say to you if they're not happy or something doesn't feel right for them in what it is they're doing with you. So having that waiver is really important, and it sets out from the beginning of your relationship with the client what the responsibility boundaries are so that you can be really clear about how you're supporting and maintaining healthy boundaries between the two of you through the journey of your relationship working together. You're going to use a disclaimer when there is no form to be completed or there's no interaction necessarily with the client, and in the US, whether it's a free or a donation class. And my example that most likely happens for a disclaimer is going to be when you're doing online videos and you can't see the clients, and it's just really good to have that disclaimer statement to ensure that you're saying, I am not going to be liable for the following things should X happen. And you want the disclaimer to be within what the law that you or business operates in permits. So different countries have different rules around what it is that can be disclaimed in order to protect consumers. And you want to ensure that your disclaimer is as wide as that regulation permits without it being held invalid by a court. And it's quite likely your insurers would quite like you to have a waiver or a disclaimer for your teaching. So it's really useful to have these to help make sure that your insurance is going to be valid should someone hurt themselves and decide to sue you. You're then also going to want to have your client terms and conditions, or your client terms of sale, your service terms, your booking terms, whatever it is that you want to call this document. They're basically going to be the terms on which your client agrees to purchase whatever your service is that you're offering. So this is when you provide a service, you want to have those client terms and conditions for your client to read and understand the relationship and the way in which you're working together. And that is going to be triggered when your client is purchasing something from you. You need to have a privacy policy at the point at which you collect any personal information about a person. That could be their name, it could be their email, their phone number, anything is going to trigger that requirement for a privacy policy if you are a sole trader, self-employed, or a company. that collection of data from somebody for your business is going to trigger the requirement of a privacy policy. And what privacy policy laws you need to have are going to depend on where your business is, but also where that person lives. So there's now increasing laws. There's GDPR for European citizens, there's a new law in Brazil for Brazilians, and there's also the Act in California for Californian residents that all require that those countries you need to start thinking, those citizens, you need to start considering complying with their laws as well as your own country's laws. So be mindful if you're collecting data from people who are outside of your own business area because you're doing online services and you're marketing to people around the world, that there may be foreign laws you need to start looking at complying with for your privacy policy. If you've got a website, you want to have some website terms of use. And these are going to govern how someone uses your website. If you've got blogs with user-generated content, whether you've got your photos and your copy and your blog content, all of that has intellectual property that you own, and you want to ensure that people who are on your website aren't copying and stealing your pictures and your content, and that it is going to be yours. You'll also want to have website terms of use if there is some kind of password, login, courses, online programs. All of those are going to want to have website terms of use. And this applies if you've got a website, full stop. Have website terms if you've got a website. The next thing that may be triggered by having a website is a cookie policy. Now, cookies are the tiny little files that follow us around on the internet so that we can be served with targeted advertising. And you can turn off cookies from tracking you and following you around on the internet. Most websites use them so that we can find out where someone's come from, where they're browsing on your website for how long, what they look at, and that gives you an idea of what people really enjoy using on your website and where they're falling off and not really engaging with purchasing something from you, or they are, and what's really working for your website. You can find this out from the host of your website, what cookies are being served, and you're going to put up a little policy that says, these are the cookies that I use, these are what I use to track. Maybe it would be Google Analytics is a form of cookie. You might be following people from Facebook to your website to see whether or not your promoted posts are getting you more people looking at what it is that you're offering. Maybe it's a promotion to your services. And that's going to use cookies, and you need to have a policy that helps people know about that. And in some countries, you may also need to give them the opportunity to disable those cookies so that they're not going to have cookies put onto their machine to follow them around. You also may want to have something around community rules and user-generated content on your website terms, or maybe in your group forum, say if you've got a Facebook group, that sets out the terms on which everyone should be interacting and engaging with each other. And that also will want to include things around sharing content that's not appropriate, illegal content, defamatory or bullying behavior, all of those kind of things. Maybe you don't want them to share promotions and sales stuff. And you also want to be thinking about your right to take things and remove them, but also your right to use any of those posts and content that people share. Because there might be some really wonderful testimonials or really beautiful things that you think would be really nice marketing opportunity that comes up from your group. You also will need to consider if you're going to be moderating that group or not, and saying that within that community rules or user-generated content part of your website terms. Or if it's not on your website and you want to stick it in a Facebook group or wherever else you're hosting that group, whatever the other platform is that you choose to use, you're going to be posting those forum or group terms in there. And that's just going to ensure that the group is being looked after and cared for by you. We've also got our image release and permission document. This in particular applies when we start to film and take photographs of our clients or of people that we work with. And we want to make sure that we've got their permission because we're capturing their personal image, which is protected under privacy. And then we may be using it for our business purposes, and therefore there's a form of commercial use. And we want to be getting their consent, their written consent for capturing that personal information. Because in several countries, capturing that kind of personal information and then using it commercially is something that's protected, and we want that to be in writing. So if you're going to start videoing clients, if you're going to be capturing photos of them, say you're doing workshops, that's when you really want to make sure that you've got that extra wording in writing that they give permission to be filmed and photographed and to be used for your business purposes, what platforms, where in the world. Then from a more legal perspective, you may want to have something like a license agreement. And this is where you might be giving out your content for someone else to use, or someone might be giving you some of their content to use. So say you're using photos online or someone else's music, you may want to have a license agreement that states what it is that you're allowed to use, how long you can use it, where you can use it, and in what countries. And that's something you might want to do and agree with someone else. And a license agreement doesn't necessarily need to be separate if, say, you've already got an employment contract. You may just have a license within the contract that you're agreeing with somebody. You also might want to have an assignment agreement if it is that something has been created, say a brand or a logo or your business name with its beautiful design and look and feel. And then you may want to get an assignment from the person who created that so that you fully own it and you've kind of bought it as a full, complete thing for you to do whatever you want with. So that gives you full ownership. And assignments need to be in writing. So you need to ensure that that is fully written. And that's really useful if you're getting someone to design something for you, or if you're making a video completely for someone to buy as their full, wholly purchased product. The last two documents to touch on might be employment or contractor terms when you're working for somebody else. So that might be delivering to a studio or into a clinic. And that's going to obviously set out the terms in which you're working together, whether or not it is a contractor relationship or an employment relationship, and what the responsibilities are going to be as part of that work together. And then lastly, the final one might be something like collaborations and partnerships. And this really is going to apply when you're co-creating things with other people, coming up with new products or services, and there's maybe training that's going to be created and that's going to be provided to people. And you might want to set out what's going to be the responsibility of which party, what the investment costs are going to be, and what the intellectual property rights are going to be at the outcome. So say you write a book together that's going to be part of a training manual. Who's going to do what writing of what chapters, who gets the graphics, who pays for the editorial, who does the marketing work, all of those things want to be set out in that collaboration agreement. And then you want to be really clear about who owns what in terms of the intellectual property and how that could be used outside of the partnership or the collaboration. There's also other forms of agreements, but these are the main ones that I would expect that you may come across if you're a wellnesspreneur. Depending on how much you're doing and making your own content and growing your business, whether some of it's online or not, you may come across some or all of these documents and maybe some more. I hope you found that a helpful overview of the kind of documents that may be coming up for you as a wellnesspreneur and the kind of things to look out for in those documents. If you enjoy my videos and you want to learn more, get a little bit more into depth about the kind of documents and seeing examples and working through them, then you can join my courses at spiritlaw.net. Sign up for the email to find out when the release dates are for those courses. And you could also just make a donation if you just enjoy the videos and that's enough for you. Those donations are greatly appreciated. Otherwise, keep shining your light, doing your awesome work, and let me know any of your requests for future topics. Thank you.